Welcome to First Thursday. Thank you everyone for taking your time today. Hope everyone had a great 4th of July. I certainly did. And today we're going to have a very interesting webinar. I love these. These are our case studies webinar. And today I've picked two cases in the asset protection realm that are pretty seminal. These are very interesting. So I know many of you on this webinar are existing Asset Protection Council members and are familiar with asset protection and have a lot of experience, and we've worked together. And many of you are not. You're brand new. And so you're kind of dropping in the middle. We do a webinar every Thursday of the first Thursday of each month. And we switch it up. So this month we're going to actually do a case study on these two cases. My name, of course, is Douglas Lodmell. I'm the managing partner and co-founder of Lodmell, asset protection law firm since 1997. And we are also the inventors of the Bridge Trust, which has really come to be the go-to option when it comes to asset protection trusts. There are other webinars where we talk about it in detail, but it really suffices it to say that the Bridge Trust is offshore protection with domestic simplicity. So if you're not familiar with the Bridge Trust, I do encourage you to go to assetprotectioncouncil.com, go into the resources tab, and look at some of the other webinar series that we talk about it in detail. I'm also the founder of the Asset Protection Council. Asset Protection Council is a network of attorneys nationwide dedicated to providing effective and proven asset protection to their clients. That's done by co-counseling with Lodmell, my law firm. So we do the heavy lifting work, and you provide high-level asset protection services to your clients. So let's jump into it. Dahl versus Dahl. This is an interesting case because in the world of asset protection, there is foreign asset protection trusts, which really started first. That was way back in the 80s, and they are by far the most established. And if I were to pick a jurisdiction to say this is our key jurisdiction, it'd be the Cook Islands, because the Cooks were literally the first jurisdiction to ever enact an asset protection trust legislation. And the fundamental basis of that legislation is that there's a statutory non-recognition of any other country's judicial proceedings, court orders, judgments, etc. So if you have a Cook Islands trust and you have a bad judgment that comes down against you in the States, it's really not worth anything in the Cook Islands. And that's really why it works. The other side of the fence is the domestic asset protection trust world. This started much later. It started in 1998. Alaska was the first state to enact a domestic asset protection trust statute. And that statute tries to mirror the Cook Islands and the offshore statutes in protecting the assets of the trust. The problem is they can't do that one fundamental thing that the Cook Islands can, which is create a statutory non-recognition of any other jurisdiction's court orders. In fact, they have the opposite restriction in place. Article 4, Section 1 of the U.S. Constitution requires a constitutional recognition of every other state's court orders and judicial proceedings. So as much as Alaska, Nevada, and Delaware would love to be asset protection jurisdictions from California, Texas, New York, New Jersey, they can't just do what the Cook Islands can do. And this is a case that really highlights that. So Dahl versus Dahl is a domestic asset protection trust case. It was 2015. And so the issue in Dahl versus Dahl is, will a domestic asset protection trust, a DAPT as they're come to be known, set up in Nevada, which is one of the DAPT states, be affected or respected in a Utah divorce case? Now, very interesting to note, Utah is also a domestic asset protection trust jurisdiction. So if there's any two jurisdictions you think a domestic asset protection trust should work, it would be between Nevada and Utah. So let's see what happens. Case summary, divorce, right? Charles and Kim get a divorce. Kim appeals the divorce action alleging a whole bunch of stuff, but one of the things she alleges is that the Dahl family irrevocable trust is marital property. Of course, this is Charles's personal asset protection trust set up in Nevada. We can all guess that he probably set this up a few years before the divorce, thinking about the divorce. But he did it with, separate assets, and probably seemed logical to him at the time. So the Utah Supreme Court consolidated the cases and remanded it. That skips ahead. Let's go to the timeline so that I can really unveil this in its details. Trust set up in 2002. Marital assets contributed to the trust thereafter. The Dahls filed for divorce 4 years later, 2006. There's 3 years of pretrial proceedings and discovery, and lots of problems. There's a 14-day trial. What a nightmare! 14 days of a divorce trial. I've seen it before. It happens. The divorce court has finally resolved in 2010. The decree is issued same month, 2010, and then Mrs. Dahl appeals, and that's in 2011. The husband's motion for summary judgment affirming the trial court granted in 2011. So basically, hey, trial court was right, go back. She appeals it to the Utah Supreme Court, and that's why this case is so interesting, is it actually got to the highest court in the state of Utah. And they published opinion in January 2015. So what happened? Trial resort, court rejected the argument that Mrs. Dahl was a settler of the trust. Trust was in actuality revocable, and the trust ultimately was excluded from the marital assets. In other words, it worked, right? The husband protected the assets. On appeal, court just granted summary judgment, affirmed the trial court's ruling. That's it. Nope, trial court got it right. This is all fine. Okay, Supreme Court. Court found that Nevada contained marital property, the trust, the Nevada trust, and should have been joined and considered as part of the divorce case. Here's the really interesting part. Applying Nevada law to the trust violated the public policy of Utah. So what did the Supreme Court of Utah apply to the trust? Utah law. Okay, well, choice of law conflicts is always a big point of discussion. I always make the assumption that the trial court or the court that you're sitting in is going to apply the law of that court. It's not always true, but it's certainly true enough to say that's my default presumption. And under Utah law, the trust is deemed revocable. Well, if a trust is revocable, then it can be revoked and it can simply be brought back. And there's no asset protection in a revocable trust. So the case was remanded down for consideration and in other words, the trust assets were considered marital. So the summary. Can you really rely on the statement of jurisdiction in the trust, or do you in the document, or do you have to assume that the court is going to apply the jurisdiction that the court wants to apply to get the result the court wants to get? I think that it's the latter. I think the courts will always apply the jurisdiction that they want in order to reach the results that they want to get. And if you're sitting in Utah or California or New York or wherever, I think you can be safe to assume that the judge is going to apply that law. That's just the way it seems to play out every time. So the court has the case in front of it. That's the law. What's the takeaway here? Well, to me, the takeaway is that you have two domestic asset protection trust jurisdictions, and we still have a complete failure of a domestic asset protection trust. Even the Utah court didn't respect the Utah DAPT statute. At best, what this represents to me is that domestic asset protection trusts are unsettled. At best, that's what it represents. At worst, it means they just don't work. They just flat out don't work. I would say that the best that you could say about a domestic asset protection trust is that it's an uncertain result. And unfortunately, most of the clients that we deal with aren't real excited about putting planning in place that you're going to tell them, we're not really certain if this is going to work. And so for me, what it means is don't use a domestic asset protection trust. Just don't use them. I don't. I just don't use a pure DAPT in any jurisdiction. I'm not saying that they're absolutely wrong to use. Don't misinterpret me. There could be circumstances where they're appropriate. Maybe if you live in the jurisdiction that has the DAPT statute and you're very specifically including assets that fit the DAPT law and you have a very specific reason to do it and you do everything just right, sure, a DAPT might be the right tool for you. But that's not most of my clients. And in general, I just don't feel like they're very secure. And so, what we have is Dahl versus Dahl, a failed DAPT. So what's the better choice? Well, foreign asset protection trust, certainly, that wouldn't have the same result, or a bridge trust, which I mentioned in the beginning is really an offshore level of protection, but with domestic simplicity. Because what we really do in the bridge trust is we file and register an offshore foreign asset protection trust. But then for Section 7701A30E, which determines whether a trust is considered foreign or domestic, we make it domestic. So it's a domestic trust for tax purposes. There's no EIN number. There's no 3520, 3520A. Client doesn't have to open up an offshore bank account. Client can be their own trustee. It's really an invisible structure. We attach it to a limited partnership or other form of holding company, and the net result is that we can really protect all the client's assets with a very simple trust and a simple structure that is less expensive and much simpler to maintain. But if we ever have a serious threat, we declare an event of duress, and that trust becomes a full foreign asset protection trust. Client is removed as trustee, assets can be moved offshore, and then we have the full protection of a foreign asset protection trust. So let's talk about a foreign asset protection trust, because that's case number 2. This is the SEC versus Solow. SEC, notice that plaintiff, SEC, bad plaintiff, just not the kind of plaintiff you want to have. What's the issue? Well, these are bad facts, I'm going to tell you before we even start. They're just horrible facts. And the planning still worked. And so let's see why. Case summary, Mrs. Solow set up an offshore asset protection trust in 2010 just after receiving notification that her husband had a big judgment against him from the SEC. So far, so good in a sense, right? The wife did the planning. If the husband had done the planning, it would have been really offensive. But here we've got the wife doing the planning. So that part in and of itself is not really problematic in my opinion. Husband got a big judgment against him. It's actually pretty reasonable for the wife to say, hey, how can I protect my assets? Where the problem comes is how she funded it. Because she funded it with her home, which was a $6 million home located in Florida. That's a Florida home which has unlimited homestead exemption, and it was held by tenancy by entirety with her husband. So she had really 2 levels of protection around the home in Florida, the tenancy by entirety and the homestead exemption. And then she transferred that home into the trust. She also transferred a corporation that owned a condo into the trust, and then equity stripped that and turned it into cash, which was parked offshore. So here's what the court found. The SEC argued that Mr. Solow was guilty of a fraudulent conveyance due to her actions. So what was the result? Well, Solow's attorneys argued that the home and the other assets were already protected by TBE, and thus transferring it into the trust shouldn't have really changed anything. They should have already been protected. Putting them into her trust was unnecessary, but since it was unnecessary, it also should be permitted. The court ruled otherwise and ordered that Mr. Solow to disgorge the $3.4 million to the court, and he failed to make the payment, and so they found him in contempt. He didn't stay in jail very long. So the net result is that it worked. It did work. However, in this case, had the Solows done nothing, they probably would have also gotten the same result, because the fact that the property was already protected by tenancy by the entirety in Florida. Here's the problem. It's this flurry of activity just days after a super creditor, the SEC, comes in with a judgment. That's what clearly colored all these assets. This was just a foul. It wasn't even that it was wrong planning. It just turned out to be a foul, and the court called it a foul. But even though it was a foul, it still worked. The assets were still protected. And also, the SEC is a super creditor. So that's always a difficult situation when you're dealing with a super creditor. So it's just had poor timing and bad optics. I mean, that's really this case. But I mean, and that's why I picked it, because it really is a bad case, right? should have done nothing, did something, and it just looked bad. It just kind of didn't pass the smell test. That was the problem with this case. Didn't pass the smell test. So it still worked. And that's really the takeaway from this, is when an offshore trust fails, when a foreign asset protection trust fails, it fails in the still working position. When a domestic trust fails, it fails and doesn't work. And that's why I say a foreign trust is really the gold standard when it comes to defending your assets. You want to be offshore. Prior to defending your assets, most of my clients don't want to be offshore. They don't want offshore accounts. They don't want offshore trustees. They don't want to have compliance requirements and so forth. So it's really, you know, your job as an asset protection planner, if you're in this business or if you're you're educating yourself about getting into this business, your job is to be able to identify and understand what a good client is, what good facts are, when you can help, when doing nothing is actually the best help. And I can tell you, I very often, I mean frequently, am telling clients your best course of action right now is to do nothing. Not because we couldn't do something, but because doing something carries such bad optics that it's going to cause more damage than good. And I am definitely not afraid to tell someone that you know, doing something is going to be a bad result for them, or even could be a bad result. So when you see things like clients coming in very clearly after the fact with big issues like super creditors, and when the client themselves, when you get the feeling that they already look like a bad guy and they're the client themselves telling you their own story, that's probably a client to just avoid. It really is. It's probably a client to just say, you know what, we're gonna pass. Best thing that you can do is nothing right now. And again, I do it all the time. I mean, I really do. I don't take clients that I feel are just going to create a problem. So I want to go to the assetprotectioncouncil.com here, because if you're not familiar already, or even if you are, I'm going to show you this website, because if you enjoyed this case brief at all, there's a whole bunch more. You go to the resources tab here. These are all resources, all related to asset protection. So there's case summaries. There's a whole bunch of cases that I've briefed, I've interpreted for you. I've indicated, you know, what the principle they really stand for is. I have a topic by topic section that really talks about everything. I mean, the last post is investing in overseas real estate. Got a lot of clients that call in and they ask about that. You know, reporting requirements, it's really very topical and very effective. There's also legal webinars that are these first Thursdays. That's what these are. So each one gets recorded and reposted. This one will be up in about a week. So you'll be able to go and revisit what we talked about today, and as well as all the other ones that we've done. So, you know, navigating the complex employment and labor law landscape. That was an excellent webinar last month, and that was given by Paul Edwards, the CEO of Cedar Solutions, which is an outsourced HR service for medical. Before that was embracing asset protection as a core competence of your practice, or core component of your practice. So all of these, if you haven't yet seen them and you want to catch up to where we are, just go back and watch them all. And finally down here is marketing your practice. We really consider ourselves a new school law firm. We use technology. We really use technology. We believe in the power of the internet, in the power of referrals, in the power of having a strong network that we can rely on, and a lot of transparency. So the Asset Protection Council is just that. I come here all the time to refer clients to my members. So if you go here to the member directory, you'll see the members. We've got them in virtually every state, and when I need a member, I will go here, because most of these affiliates are, asset protection is not their main thing. In fact, it's usually something else. They're usually part of this, or they're virtually always a part of the Asset Protection Council in order to affiliate with Lodmill so that they can provide high-level asset protection services. But they are very good at everything else. And so when my clients need estate planning, when they need business planning, succession planning, all of that, and if, for example, if they were in Washington, I would refer them to John Kenny. Why? Because John is on my website. I know him personally. We've worked together, and so I can very confidently refer him. And we end up referring a lot of business. So if you're not a member, become a member. I really encourage you to. Get your picture, get your bio up here. Educate yourself on the resource tab about all the areas of asset protection. Learn to market your practice or enhance the marketing that you've done. And just get better at what you're already doing, because you can always serve your clients better. So that's it. The resources are all here. Here's my schedule. August 3rd, we're having First Thursday webinar, of course. I'll be in Philadelphia on the September 21st, the Estate Planning Council there, speaking to lawyers. They invited me up because, again, this topic is very topical. October 3rd through 6th, we'll be in Hollywood, California with Wealth Council. Wealth Council is a great organization, and we really enjoy. We've been speaking at their group for about 4 years now. And then this year, I'm the keynote speaker at the National Association of Estate Planning Council in New Orleans. And if you're a member of either of those groups, I would really encourage you to come to the appropriate presentation. Those 3-day events are awesome. I mean, they really are. There's so much going on. It's a very interesting community to get involved with. Lots of incredible resources, and I look forward to it every year. So that, and if you're going, let me know. Say, Doug, I'm going to be there, and then we'll make sure we spend some time together. You know, that's a real benefit, and please let me know if you are going. And any questions? What is the best combination of NLEs to utilize? Okay, so this kind of gets back to how we do our planning. The way that we typically end up structuring a client is by using a limited liability company for your lowest level assets, like real estate, businesses, anything that, you know, has some risk to it, rental properties, etc. But we like to consolidate those up into a holding company. And the form of holding company that we like the best is actually an Arizona Asset Management Limited Partnership. So it's kind of like a family limited partnership, but really designed with asset protection in mind. And we use Arizona because Arizona is just a very protective state when it comes to charging order protection. They've extended charging order protection to single member LLCs. They're just very aggressive. It's a real, you know, get off my land, shoot you if you're here, ask questions later. That kind of comes through in the legal side of the state as well. There's also no annual registration with the state. So once you register a limited partnership in Arizona, it's good. You don't have to even go on to the website and click a box. And that makes a difference when you're doing thousands and thousands of them. You want to make sure you don't create a maintenance nightmare. And so I just really like to find, and that kind of philosophy will run throughout my planning. I'm always looking for a way to make it unclick a lever, you know, remove a lever, you know, as few moving parts as possible to make it work. You know, that's why I like the bridge trust, which, okay, so in the planning, the bridge trust will then be the majority limited partner of the limited partnership. And as the majority LP, it owns all the assets. And then Arizona also has a very cool section in their limited partnership statute which allows for a limited partner to unilaterally withdraw from a limited partnership upon the occurrence of a predefined event. And that event, of course, is an event of duress, which is declared by the protector. So that allows us to basically cause the limited partnership to distribute assets to the trust without the client making that declaration. So that's the typical structure. It's usually those three tools. If there's no real estate or lower level assets and we're just talking about a liquid portfolio, cash, and maybe a home, then you wouldn't need any LLCs. Liquid assets can go directly in the limited partnership. They just go straight in there. So brokerage accounts, etc. And so then we're just talking about the asset management limited partnership and the bridge trust. So great question. Thank you. All right, next question. When using a domestic asset protection trust, a DAPT, should you also combine it with a charging order entity, like an LP or an LLC? Okay, so the answer to should you combine an asset protection trust with a charging order protection entity is yes, virtually always. I love having charging order protection in addition to a full asset protection trust. I wouldn't use a DAPT at all, so I would use a bridge trust combined with the charging order protection entity, or a fully foreign trust combined with the charging order protection entity, just for the reasons we stated. You know, the bridge trust is got the capacity to become a full foreign asset protection trust, whereas the DAPT does not. It's just what it is. Now, I know some people will say, no, Doug, a DAPT does. It has a flee provision in there. You can always go offshore. And my answer is it is not as easy as it looks. Trying to get an offshore structure set up from a domestic structure after there's a problem is a problem. You will have trouble finding an offshore trust, an offshore jurisdiction, a trustee, and a bank. All those things will be difficult for you. So the bridge trust solves that by lining all that stuff up beforehand. That's what makes the bridge trust different, is it's all pre-wired. The trust is already registered offshore, and there's already an offshore trustee in place. So we don't have that issue, and that's why I like the bridge trust. But to answer your question, yes, you should combine any asset protection trust with a charging order protection entity like an LP or an LLC. Great question. Okay, next question is, are you available for a conference call with me and my client? Absolutely, of course. That's why I'm here. That's why we're doing these webinars. That's what the APC is all about. Again, for most of the APC members, you know, asset protection is not what you've done for the past 20 years. You know, you've got a robust practice, and now this is new. So the whole goal is for you to be able to add the highest level of asset protection in with no startup time. And you do that by co-counseling with me. And the way that we do that is that, yes, I get involved with the client right from the initial consultation. This allows me to really run with the ball. You'll see exactly how I do the analysis, exactly how I present it, everything, and you're there for the whole process. What we found is that it takes 5 or 6 deals for you to really get comfortable and to see how that process goes. And then I start having the affiliate attorneys just sending in brand new clients without a lot of extra need for me to come in and do the conversation. Some are just the opposite. They just send me the referral and they don't even necessarily want to be on that call. However you want to do it. But absolutely, to answer your question, I am available to meet with a client. Just call Kitty or Coletta, who keep my schedule in Arizona, and they will schedule you and we will do it. I would schedule just about an hour for that. It typically doesn't quite take an hour, but sometimes the questions will run an hour if there's, you know, if they have a lot of questions. Great question, thank you. Okay, next question, is there a cost to become a member? No, there's not a cost. And I want the barriers to entry to be low. There is a qualification in the sense that, you know, I want to talk to you. I want to make sure there's a good fit. I want to make sure that, you know, your practice is a good fit. And as much as anything, I want to understand your practice so that I know what you're offering as your core competency services, because I really do refer back, and so do the other affiliate attorneys. And as the network has grown, we've started to see a lot more cross-fertilization and cross-referrals. Sometimes a client will move from Denver to San Diego, and you need to make a referral to an attorney in San Diego. Well, we have a great affiliate attorney in San Diego, and you can look there. You know that they're going to understand the planning that you and I put in place for the client. They're going to support it. So it's really about building a very supportive network for all of us. And there is no cost. Where our interest lies, obviously, is in co-counseling the cases with you. We want to do the co-counseling cases together. And of course, we both make money when that happens. But there's no cost for you to be a member. I would email Kitty, Kitty, at lodmill.com. If you're not a member, ask her to send you an affiliate attorney package, get it back, schedule a call with me, and then if it's a great fit, become a member, and we'll get you up on the website, and we'll start working together. So that's it. You'll probably notice that this website, this webinar is, I try to keep them at about a half an hour. That's about the attention span that I like to be at a webinar for, and so that's what I try to keep mine at. Here's the website, assetprotectioncouncil.com, and I really do encourage you to become a member. get the package, schedule a call with me, and definitely start thinking right now about your clients. And what I'll leave you with is the biggest thing I hear is, Doug, I don't really have a ton of clients like you do. I know most of my clients just aren't worth 10 or $20 million. And my response is that my average client net worth is around $2.5 million. And it used to be more like $1.5 million. The clients who need asset protection the most are what I call the target zone clients that have between $1 and $5 million of net worth. It's a $700,000 of equity in their home in a state that doesn't have a good homestead exemption. It's an $800,000 brokerage account. It's an office building with $400,000 of equity. That's my average client. And the reason that those clients make up the bulk of my clients are because they need it the most. They're now 50s and 60s. They have $2 or $3 or $4 million of assets. They have enough to retire in a way that they're going to be happy, but they don't have enough to lose. They really can't wait around to lose it. And that's why they're so motivated around asset protection. So if you are thinking about your clients and going, I just don't think I have that many, think again. I bet you do. I bet you have a lot that fit that profile. $1, $2, $3 million in net worth, have a business, have employees, are a medical professional, have risk. All of those things count. I would encourage you to make a list, a short list, 3, 4, 5 people. Call me up. Let's go over the list. We'll just do a quick briefing on them. We can talk it through, and then we can come up with a plan to get those clients on the phone and do an analysis together. Thank you so much for joining me, taking your time out of the day. Have a great summer, and we will see you in August. Remember, it's your money. Act like it.